This conference will now be recorded.
Good morning, everybody, and welcome to this session this morning. And I'm delighted to have with me Karen Fletcher from Bradshaw Trees Law, who's going to be talking about hiring and firing staff. This session is being recorded, so if you want to catch up on anything you might have missed, it will appear on our YouTube channel later on today. As always, we have to read out our usual disclaimer. So the following presentation is produced for general guidance only, and general guidance only, and professional advice should always be sought before any transaction is undertaken. So individual circumstances can vary, and therefore no responsibility can be accepted by Harts Limited or any of the affiliates for any action taken or any decision made to refrain from action by attendees of the presentation. Okay, that's the legal bit out of the way. A quick update, as we do before all our webinars. Yeah, we've had a budget, and I'm sure everyone's been reading about it in the news. If you go to our website, there's full details under the latest news session. Latest news section there. But driving in this morning, you're listening to Liz Truss explaining how wonderful she is and what wonderful things she's done. That's your matter of opinion as whether you agree with her or not. The markets certainly haven't. But basically, to summarise, we've got tax cuts all the way. Got rid of the 45% bracket, reduced the 20% down to 19%. IR35 is an interesting one. Is those of you involved in your own personal service companies, acting subcontractors and so on, then IR35 is going back to the original rules. It hasn't been repealed altogether, which seems to be a little bit misleading about what's in the press so far. So it is still there. It's going back to the subcontractor to make the decision as to whether you're under IR35 or not. The old rule, this will be repealed, I think it's in April next year it's going to happen. So just be aware of that. Gift aid donations, well, because of the reduction from 20 to 19%, the amount of gift aid potentially is going to be reduced. However, there are some provisions to help the charities reclaim 20%. Pension contributions, much the same. You're not going to get as much pension tax relief as you did previously, and be even more so with if you were a top rate payer. So you just need to bear that in mind as well. Full details again under the latest news section on our website. Capital allowances is a good one as well. They're giving away more money here. It was the maximum you could claim in a year was 200,000. And that was due to end fairly soon. It's now, but we had a transitional rules at £1 million worth of capital allowances available to you. That is now going to become permanent at £1 million. So there is a lot more relief available for capital allowances going forward as well. And they have increased the limits, investment limits for seed enterprise investment scheme and company share option plans. Again, lots more information if you go to the news section on the website. Other resources, if you want, you can have a look at our other resources which are available, which is basically following us on LinkedIn at Harts Limited. You can subscribe to us on YouTube at Harts Limited, and please follow us on Twitter, Harts Accountants. And we're also now on Spotify. We've recorded another 3 podcasts recently. We were talking about it before some of you have actually jumped on. And we've just done one in relation to an insolvency practitioner, which is now it's going to be on Spotify shortly. It's interesting insight into what insolvency practitioners actually get up to. And you'll be able to hear about how difficult their life can be sometimes, in as much as this guy has had himself pushed up against the wall, he's had his car keyed, his headlights put through, all because he's had to tell people they're losing their jobs. So it's a very fascinating insight into what actually goes on. So feel free to listen to that. It's on YouTube and will be shortly on Spotify. The next webinars that we've got, the next one's next month on the 20th of October, is on relation to employee ownership trusts. And if you're thinking you're selling your business to your employees, have a think about employee ownership trusts. We're going to have Chris Bentley explaining what they are, how they work. There are significant tax advantages in this. So it's well worth you having a jump on to this if you're considering selling your business. And On the 10th of November, we're going to be talking about giving the customer the wow experience and making your customers feel great by giving them all this experience, and what you actually should be doing with them to make sure that they actually stay with you. And then on the 1st of December, we're going to be looking at making tax digital. There's been a lot of talk about this, about what you should and shouldn't be doing in relation to making tax digital. There is major changes coming in if you are a sole trader or you're a landlord, and we're going to explain what it all means to you. We've just recorded a short video which is on our will be shortly on our YouTube channel as well, and be on Spotify as well. But there's lots of issues which you need to be considering now. Even though it might only come in until not come in until April 24, it's something you need to be considering now. Okay, that's enough from me. What I'm going to do is I'm going to make our guest speaker the presenter, and I'm going to introduce you to Karen Fletcher from Bradshaw Trees Law, who is an expert employment lawyer who's been around the big firms, some national firms setting up employment departments there, and has recently set up her own firm. So I'm going to hand over to you, Karen. Over to you.
Thank you very much, Stephen. Just to check, has the PowerPoint come up for you?
We've just got your copy of the screen with all the...
Right, okay, apologies. Let me just try again. We had this working before, didn't we? And now,
yes, we did.
of course, as soon as it actually matters, has that worked?
That's it. That's it. We're there.
Fantastic. Thanks, everyone. And thank you for inviting me today as well. I know Stephen's just given me a brief introduction, but for those of you who don't know me, I'm Karen Fletcher, owner of Bradshaw Trees Law, and we're employment law specialists. A bit of my background, I qualified as an employment lawyer back in 2003, spending 10 years in the employment team at Adelshaw Goddard, then 3 years setting up a new employment team in the Manchester office of Shoesmiths. Family circumstances meant I needed a more flexible role, so I became a self-employed consultant, delivering employment law advice through Analysis Legal. But in December last year, I set up my own employment law firm and now have 4 part-time consultants with similar background experience to me who help me to deliver employment law services to all of our clients. I'm also recognised by Legal 500 as a leading individual in employment law in the Northwest. So today I've been asked by Harts Accountants to give a webinar on hiring and firing staff. First, we're going to look at how to take on new staff, and then how to deal with problem staff, and then we'll finish with a Q&A session where you can ask me any questions. So let's start with taking on new staff. Here, we'll first take a look at the law and what you legally have to provide a new employee. This is a long list, so be warned. We'll then look at other clauses to consider including in your employment contracts, and some good practice for managing employees and reducing issues that might arise. So let's look at the legal requirements first. Since 6th of April 2020, apologies, just a minute, I'm just going to turn something off. Sorry about that. We've swapped offices and there's a Google Office in the background and it keeps going off, so I've just unplugged it. So sorry, we were talking about since 6th of April 2020, employers have been required to provide employees and workers with a written statement of particulars of employment. This document can also be called a Section 1 statement, a contract of employment, or a service agreement, which is typically used for very senior members of staff or directors. There is no minimum service requirement for an employee or worker to be given a Section 1 statement, and it's best practice to give the statement prior to the employee or worker starting work. However, there are some of the particulars that may be given no later than 2 months after starting work. So Section 1 of the Employment Rights Act sets out the matters which the written statement must include. So the statement must include the names of the employer and the employee or worker, the date when the employment began, the date on which the employee's period of continuous service began, and this can be a different date, it's sometimes the same date, but if, for example, there's been a TUPE transfer and someone's employment is recognised from a previous employer, then it'll be the date on which they started for that previous employer. And it's important that the contract includes both of those dates, pay details and the method of calculating pay, how often they'll be paid, whether it's weekly, monthly, or some other variable. Any terms and conditions relating to the hours of work, including normal working hours, the days of the week which the employee is required to work, and whether or not such hours or days may be variable, and if they are variable, how they're going to vary or how that variation will be determined. We also need to look at holiday entitlements, including public holidays and holiday pay, and the calculation of holiday pay on termination of employment. The statement must deal with the length of notice that must be given by either party to terminate the contract, and it must also include either a job title or a job description. Where the job isn't permanent, the period it's expected to continue or the date that it will end. The statement's got to talk about any probation period that applies, including the conditions of probation and its duration. It needs to specify the place of work, or if the employee is required to work at various places, an indication of that and the address of the employer. The contract must also say whether or not the employee is required to work outside the UK for more than 1 month. If they are required to work outside the UK for more than a month, the contract must specify the period of time they'll be working outside the UK, the currency in which they'll be paid while working outside the UK, any additional remuneration payable to them and any benefits whilst they're abroad, and any terms and conditions relating to their return to the UK. The contract must also specify details of any training which the employer requires the employee to complete, and any other training which is required but the employer will not pay for. It must also talk about any other benefits which are provided by the employer. So, for example, if an employee is eligible for a non-contractual bonus, the Section 1 statement should include that fact within the statement itself. It must also include any terms and conditions relating to sick pay and sickness absence. The statement must also talk about pension and any terms and conditions relating to pension and pension schemes. It must specify whether or not any collective agreement applies, and if a collective agreement does apply, details of where that collective agreement can be found. Any training entitlement and a reference to where the disciplinary procedure and grievance procedure can be found. So some of these requirements can be referenced in the Section 1 statement and contained in a readily accessible document such as a staff handbook, and this includes the disciplinary and grievance procedures, sick pay, other paid leave and pensions. So in addition to Section 1, there's also part of the Employment Rights Act requiring an employer to give what's called a Section 4 statement, which is where there's any significant changes. So wherever there's significant changes, the employer must give that Section 4 statement at the earliest opportunity and no later than 1 month after the changes apply. So what happens if an employer fails to provide either a Section 1 statement or a Section 4 statement regarding significant changes? Well, an employee or worker can make a complaint to the Employment Tribunal where they've either failed to provide that statement altogether or they've provided an inaccurate or incomplete statement. The tribunal will then decide whether there are any particulars which ought to have been included or referred to in the statement to make sure that it's compliant. And they may also award between 2 and 4 weeks' pay, depending on how serious the breach is. So it's not a particularly valuable claim, and it does tend to be a claim that's tagged on to a claim after somebody's left. But employees can bring a claim at any time during their employment and within 3 months of the end of their employment. So that's all the law. If we look at some additional clauses that from your business perspective you may want to consider including, we've got confidentiality provisions. So there are some common law protections in place to protect an employer's confidential information, but it is preferable to set out any obligations to keep confidential information secret and not use confidential information in a future role for certainty.
Karen, can I just interrupt? Sorry,
Yeah,
quick one.
sure.
The slides are still on slide 6, is that correct?
Oh, no, it isn't. Sorry, they're not on my screen. Let me just, I'll tell you what, I'll go
Yeah,
out and then come back in again.
yeah.
Can you see, have I still stopped sharing?
Yeah.
Yeah, let me try again. Can you see now?
Yeah, we're at slide 14. If you click the top right left-hand corner from beginning, and then you can just press next to
The only
progress.
problem is I am on slide 14 unless you want me to repeat everything.
No, that's fine. That's fine.
Yeah.
Okay,
So,
no problem.
yeah, sorry about that. I think there must be a problem when I go to slideshow. So I'll keep it on
Okay.
this screen so that you can still see
Yep.
everything.
Yep.
Okay, so we were just talking about some additional clauses to consider, and we talked about confidentiality provisions. We're just going to move on to restrictive covenants, or sometimes called post-termination restrictions. So these can be difficult to enforce and are a topic in their own right. However, they can be a useful tool in protecting an employer's business after a key employee has left, by preventing an employee from working for a competitor, preventing them from poaching key staff, key clients, or interfering with supplier relationships. And they can only apply for a set period of time, which tends to be between 3 months and 12 months, depending on their seniority and how much damage they could cause.
When you have these clauses, sorry to butt in, when you have these clauses,
Yeah.
we often see 18 months put in. Is it just totally unenforceable if someone does that?
If they put what, sorry?
18 months in as a kind of
if it was somebody, you'd have to be able to justify that. So it very much depends on the factual situation. And the key with restrictive covenants is to consider them at the time that you're putting them in place as to what period of time is reasonable. Now, for example, in the insurance sector, where clients tend to only renew every year, sometimes you can justify longer covenants because otherwise you don't have the protection in place. But
Okay.
for most situations, like the shorter the period, the more likely it is to be enforceable.
Okay, thank you.
So also protection of intellectual property. So if you have any employees who are likely to create valuable intellectual property in their role, you should consider claiming the rights to such intellectual property in the contract of employment. Data protection is another big one, particularly since GDPR. So I recommend including clauses in your contracts of employment, obliging employees to sign the employer's privacy notice, setting out how the employer will deal with data, and requiring the employee to comply with any obligations regarding the employer's handling of data. Working time opt-out. So if your employees are likely to work more than 48 hours per week on average over a 12-week period, consider including an opt-out of the working time regulations. However, please note employees should never be forced to sign this opt-out, and they should be able to withdraw their agreement on up to 3 months' notice at any time. I haven't put this on the slide, but other clause to strongly consider putting in is a payment in lieu of notice clause or a garden leave clause. So a payment in lieu of notice clause, sometimes known as a pylon, allows an employer to terminate a contract immediately and pay in lieu of notice, which can be useful. It's very important to include a pylon where there are restrictive covenants, as otherwise, if an employer terminates the contract immediately, all contractual terms fall away and the restrictions will no longer apply. Garden leave is often included for the same reason, so that employers can protect their business interests where an employee tends to leave and join a competitor. So again, the idea is that they continue to work for the employer, they're just not required to do any work or come in, which can give the employer a little bit more time to establish new relationships with key clients that particular employee has been dealing with. There are other clauses which can be helpful to your business, particularly if you believe the business may be sold in the future, but these are outside the scope of today's webinar. So moving on now to the processes. Which processes are particularly important? And again, this is almost like a topic in its own right, but I've just chosen a few important ones just to talk about. So probation periods. I highly recommend proactively managing probation periods. I've spoken to so many employers over the years who knew that an employee wasn't a good fit for them during their probationary period, but stayed silent or didn't raise any issues at the time. We all get busy. But the probation period is there to check whether the employee is right for the team and whether the employer is right for the employee. So ensure you hold a meeting mid-probation period to review performance to date and arrange a further meeting at the end of the probation period to consider whether to confirm the probation has been passed, whether it's been failed, or whether an extension is required. I also recommend actively managing expectations and performance from the start. Proactive management of employees leads to higher performance and less issues with staff overall. So ensure you're clear with your performance expectations and encourage employees to raise any problems or concerns they may have at an early stage. It's very difficult to raise performance concerns about an employee when they've worked for the organisation for many years without any issues ever being raised with them. On the same theme, ensure your employees are familiar with your policies and work rules. A staff handbook is a very useful tool to have in place. So it sets out the employer's expectations and policies and how employees will be treated in various situations. So train employees on the more important policies and work rules, such as equal opportunities, either in their induction or very early on in their career. And the final one, just for the processes that I've picked out, is the importance of having clear absence procedures in place. So active absence management procedures are a very useful tool in managing sickness absence. So ensure you have a clear reporting process in place and consider requiring a phone call to the line manager rather than allowing text messages or messages passed on through colleagues when people are ill. Also consider whether it's appropriate to hold return to work interviews after every absence, or if less frequently, the circumstances where you're going to hold a return to work interview. Explain the circumstances in which return to work interviews will be held in your absence procedure to ensure consistency in approach and manage expectations. If you have anyone on long-term sickness absence, ensure you keep in regular contact with them so that they feel part of the workforce still and you keep updated as to their prognosis. If you do need to seek medical advice to check what on their condition and how long they're likely to be off work, remember that you need to seek their permission first and comply with the Access to Medical Records Act. So we're going to move on now to look at problem staff and what to do. So it's always worth bearing in mind what someone's rights are before dealing with problem staff. So the right to bring an unfair dismissal claim requires 2 years minimum service. And this is actually 103 weeks because it's extended by the statutory minimum notice of 1 week. So if you have someone who's in the first 2 years of service, if they can't bring an unfair dismissal claim, you can sometimes follow a shortened procedure in order to end their employment. However, you do need to be aware of discrimination, trade union, statutory rights and whistleblowing, because any dismissal that's related to any of those 4 things don't require any minimum service. As long as you're implementing a consistent approach though, don't shy away from a performance or attendance issue because an employee has a protected characteristic or they're a trade union member or they've complained about something. It's only where the treatment is connected to that protected characteristic or the trade union membership, etc., that an employee would be able to bring a claim. Wherever an employee has got 2 years or more service, then the employer must have a fair reason for dismissal and follow a fair procedure to avoid an unfair dismissal claim. So in terms of finding a fair reason to dismiss, there are 5 potentially fair reasons to dismiss. Capability or qualifications, which would include performance or absence issues, conduct, redundancy, breach of a statutory duty or restriction. So that would be, for example, where someone no longer has the right to work in the UK, so it would be illegal to employ them. And then the catch-all provision, some other substantial reason, which basically gives an employer any kind of reason as long as it's reasonable. So as well as having a fair reason for dismissal, employers must also follow a fair procedure. So firstly, a tribunal, if it got that far, would look at whether the employer's reason for dismissal was fair. They will then look at, did the employer follow a fair procedure? Here the employer is required to carry out a reasonable investigation, including taking statements from anyone who witnessed events, provide any documentation which is relied upon in the hearing to the employee, and that must be in advance of the disciplinary hearing, including witness statements. I'm often asked about that. And it must give the employee time to prepare as well. They must receive a written invitation to the meeting, which sets out clearly the allegations against them, the potential outcome, and the right to bring a companion. Then the employer must consider all of the evidence, including any comments from the employee during the disciplinary hearing, before they reach the decision. If they've already made their decision before they do the disciplinary hearing, then that would be an unfair dismissal. The decision then needs to be provided to the employee in writing, and they must be given the right of appeal. Ideally, the investigating manager and disciplinary manager should be different, and the appeal manager should be more senior than the disciplinary manager. Sometimes in a smaller company, someone at the same level may be reasonable, but ideally you really need that escalation up. And then a tribunal will look at whether the reason and the procedure fall within what's called the range of reasonable responses. And if the tribunal find, even if they disagree with what happened, as long as it falls within that range of reasonable responses, then the dismissal will be fair. So as you'll appreciate, that can take quite a lot of time and effort. And so we do have a tool which can end employment without having to go through all of those processes, which are settlement agreements. And these were formerly called compromise agreements, but they have been settlement agreements for some years now. So a settlement agreement is a legal document under which an employee agrees to waive all their rights to bring claims arising from their employment, with two exceptions being latent personal injury and pension, in return for something. Employees must take legal advice on the settlement agreement for it to be legally enforceable in respect of statutory claims. So again, I quite often have clients who come to me and say, oh, we don't need to bother with them getting legal advice. They've agreed everything, it's all fine. But you are running the risk there that they can still bring an unfair dismissal claim, for example, or a discrimination claim. So an employer normally pays for the employee to take legal advice on the settlement agreement. And the settlement agreement must comply with the statutory requirements in order to be valid. And another thing just to note when you're having these conversations is that notice pay must always be taxed before any tax-free compensation is paid. I've had many cases where employers have promised tax-free money to an exiting employee, including their notice pay, and that just can't be done anymore. So then it just ends up being either more expensive for the employer, or they've got to go back to the employee and explain that actually they can't make good on what they said. So how do you have that conversation with an employee to get to the stage where you can agree some form of settlement agreement? Well, what you do is hold a protected conversation. So an employer can hold a conversation with an employee about a potential exit, and that's sometimes referred to as without prejudice, a protected conversation, and/or off the record. In the past, there was no such thing as a protected conversation, and that caused difficulties in some cases where employees had no idea the employer was considering an exit from the business. And this is because there has to be a dispute before a conversation is genuinely without prejudice. So as a result, the government introduced the concept of protected conversation, which doesn't require a dispute. Despite all of this, I do recommend that employers are still careful with these conversations, as any discrimination can be relied upon in a future claim. It's also easy to fall foul of the specific rules for a conversation being genuinely protected or without prejudice. However, in my view, tribunals are fully aware that these conversations take place, and so provided they're handled sensitively, reasonably, and with empathy, even if they end up disclosable, it shouldn't prove any real issue to defending any subsequent claim. So bearing that in mind, employers should always present an exit package as an option for the employee, with any decisions subject to internal procedures if the employee doesn't wish to take the exit package. So just to give you an example, a poor performing employee whose role is clearly not redundant, an employer may meet with the employee to say they're about to start a formal performance management process, during which the employee will be given support to improve. However, if their performance remains below standard, ultimately they may be dismissed from the company. And while the employer is happy to go through that formal performance management process, they want to have a protected conversation without prejudice and off the record. And if the employee is willing to hold that conversation, they can then present the package, which is the alternative to going through a formal performance management process. The employee should then be given time to consider this option before deciding what to do. And invariably, they do tend to take the settlement agreement option. So how much do you need to pay in an exit package? Well, exit packages do range hugely depending on the circumstances. Sometimes it's just a factual reference only, and that's where, for example, an employee's committed clear gross misconduct and they just want to avoid having a dismissal on the record, through to packages worth millions. For example, where rights to shares, which would normally extinguish on termination, are still granted. Typically, though, packages range between 3 months and 9 months' pay, depending on the circumstances. So that brings us to an end of the kind of the hiring and firing staff part. But I'm now open to ask any questions, answer any questions that you might have.
Thank you very much, Karen. I've got a question. What happens if you've got two directors, shareholders, 50-50 owner in a company, and one's obviously not performing, but maybe one other is? How do you get rid of the other one? It might be quite a difficult scenario.
Yeah, it is. Do you know what? I've got an incredibly good commercial litigator who deals with director disputes, and I tend to pass them on to him. It tends not to be an employment issue. Now, it's difficult in those situations because of the shares and the company and how you're going to split it up, rather than try and deal with it as an employment situation. Sometimes I work in conjunction with a commercial litigator in order to do that, but I always think it's better to head that as a director dispute rather than an employment issue.
Okay, interesting. Anybody else got any experiences they want to share, or any other questions that they want to ask? Feel free just to unmute yourself and shout out, because I think we've had a fairly comprehensive introduction to hiring and firing staff. What I will do is I'll make the slides available to everybody. If Karen, you can email me over the slides, and if you just drop me an email, we can email the slides over to you.
Yeah, so that's absolutely fine. Yeah, apologies for you not seeing half of the slides. I hadn't appreciated. My screen was still running along nicely. So
okay, yeah, no problem. Anybody else got anything they want to ask? We've got nothing.
I've got a question. Thanks for that, Karen. That was really interesting. We're about to recruit, and we're quite a small company, so we've done it quite informally in the past. But I was just wondering if you've got any advice in terms of, are there any legal obligations we need to be aware of, sort of in the actual process of recruiting?
There's not really, other than the fact that you have to provide the information that we ran through at the start. As far as good practice is concerned, it is always good practice to hold some form of induction and some form of welcome. So, it's important for an employee to feel part of the company from a very early stage, I think. So that can really help in terms of getting somebody to settle in. But in terms of legal obligations as such, I mean, you need to make sure that they're familiar with the handbook and the policies at the employer. But other than providing the Section 1 statement, legally, that's all you need to do.
So there's nothing in the actual recruitment process which you can and can't do. I mean, presumably, I know you can't ask ladies if they're going to have children or something like that. Is there that sort of thing?
You've got to be sensitive, and you've got to avoid anything that could amount to discrimination. And that's the same with your procedures for appointing someone as well. I mean, the things that can help in terms of equal opportunities are looking at where you're advertising roles and make sure that you're encouraging a wide, diverse range of applicants rather than sticking to the same ways of recruiting every time. So companies that tend to rely on staff referrals will end up with a much less diverse workforce. So just think about your recruitment policies in that way to ensure that you're encouraging a wide variety of applicants. And again, with the interviews, it can be helpful to have set questions for each employee or prospective employee, just to avoid any kind of discrimination. But as a small company, you have got the flexibility. If it's easier for you to have a conversation with someone, then as long as you're not saying anything that, is out of kilter with modern times, you should be fine.
Great, thank you.
Thank you, thanks.
Anybody else got anything they want to ask at this stage? And I'll just check in the chat box. I don't think we've got anything else in there. No, got nothing else in the chat box. You've got Karen's details on there. feel free to take a note of them. I'm sure she'll take any questions off the record. But thank you all very much for joining us. I'm going to stop the recording now. So if you want to have anything offline, that's fine. But thank you all very much indeed for joining us this morning, and I look forward to seeing you on our next webinar.